Good morning, all my students. Today the online class is going to start very soon. Okay, so now please come to this online classroom. We are going to resume our class in a few moments. Okay, just now in the first part of the lecture, we discussed the doctrine of misrepresentation. Okay, so now after the break for about 15 minutes, we are going to resume the class in a few seconds. So all my students, please therefore come to this online classroom right now. Okay. Again, please allow me to proceed to my desk in order to deliver my lecture right now. Hello, good morning. Hello. We are now resuming our class, okay? A while ago, we had just finished the first part of the lecture. Remember, we are discussing the doctrine of the English law doctrine before the break. We talked about the doctrine of misrepresentation, and there remain at least two more doctrines to be dealt with. Okay, in this second part of the lecture, we will discuss the doctrine of first of all the Duress. Okay, the doctrine of Duress in English law, and secondly, we will look at the doctrine of undue influence, also in English law. All my students, please be reminded that we are going to discuss English law doctrines, okay, in order to provide you with opportunities of comparing the positions in English law with the positions in Thai law. Okay, that even though we are now in this country in Thailand, and we of course apply Thai law to contracts, need is also felt for us to know, okay, the English law as well, because now we are in the era of internationalization and globalization. Okay, so that normally when we draft contracts, many contracts are in the English language, so they are in a way drafted by lawyers who are from common law jurisdictions. So when those lawyers, they draft contracts, they seem to make use of English law doctrines, okay, not Thai law doctrines. So if we know, English law doctrines, we are going to find them very useful. Okay, we are going to find it very useful. Okay, for us to, in fact, understand contracts. Okay, so if when you leave the law school and you enter a firm, a law firm, okay, the firm of lawyers, then you will find it very useful. Okay, when you are well equipped with some doctrines of English law, you will find it very useful. Okay, and very convenient. Okay, to understand the concepts which are embodied in the contracts drafted in the English language. Okay, so remember we talk about the doctrines which are related to the protection of parties against any will which is not free, or the will which is not genuine. Okay, the laws of all jurisdictions seem to have doctrines which are dedicated to making sure that the will of the parties is free will and is genuine. Okay, so we have seen the principles of law, okay, as contained in our civil and commercial code. We have seen the principle of law regarding the fraud. We have seen principle of the law regarding the duress, and also that we have seen principles of law regarding the mistakes. Okay, so when we have understood Thai law, then we should be able to compare English doctrines with the doctrines in Thai law. Okay, so let's now move on to consider the doctrine of the duress, and then we will move on to our discussion of the doctrine of undue influence. Okay, before I start, okay, let me just extend some of my worries about the injustice which which plagues Thailand now. Okay, so we are now having some politics which seems to be not very not very satisfactory. Okay, so that nowadays there are some demonstrations by people. Okay, so many people who seem to stage the demonstrations. Okay, even though the demonstrations seem to be peaceful, people seem to be they're unreasonably attacked by the government. So this is my worry. So I beg for the peaceful the handling with the people, okay, who stage the demonstrations in a democratic way. Okay, so that is something which I need to address, okay, before I start my lecture. It is not my main job, okay, to just talk about politics. The main concern is with the law, so that I just would like to just address this few words, and then we come back to our lecture. Okay, let's look at the lecture coverage again. Okay, so as I have mentioned, okay, we will talk about the doctrine of juris in English law, and then after that we will just move on to discuss doctrine of undue influence also in English law, right? So starting with the doctrine of juris. Okay, then let's have a look at an overview of the doctrine of juris in English law, as with what we have seen in the Thai doctrines, okay, of juris, right? I mean, the nature of juris is what? The nature of juris is something very, 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 very similar to what we have seen in Thai law. In fact, it is not different, okay? So when we talk about juris, it is concerned with a threat. The threat, okay, which is exerted by one party on another party, okay, and that threat leads to the other party making a contract, okay, or making in Thailand, okay, we have the concept of juristic acts, but in the English law, okay, they do not have the concept known as a juristic act. Okay, they have only the doctrines of contract law. Okay, so when we talk about doctrines in the English law, okay, then we talk about the doctrines in English contract law. Okay, but in our country, in Thailand, we talk about principles of law relating to juristic acts. Okay, so now back to the nature of juris. Of course, it is a threat which is employed or which is exerted by one party or another, in order to lead the other party, okay, to in a way the conclusion of a contract with the first party, so that we can see that when a contract is concluded under juris, then the will of a party is not generally free. Okay, the will is in a way overboard. Okay, so that we come across this word overboard will. That means that the will of a party is dominated. Okay, it is not free. It is dominated by the party who exerts a threat. Okay, so we can see that when the party's will is not generally free, but it is in a way dominated by the first party, then there is too little reason for upholding the contract. Okay, the contract in question should be allowed to be set aside. Okay, set aside by the party who suffers injury. Okay, as a result of a threat. Okay, so this is an overview of the doctrine of juris. Okay, this is the nature of juris. Okay, so the nature of juris is not different from the nature of juris which we have seen in Thai law. In essence, it is concerned with a threat, okay, in some way, okay, and the threat will lead to the situation in which the other party, the party who is threatened, okay, has no practical choice. Okay, so if we look at how the doctrine of juris in English law has been developed, we will see that the development of this doctrine of juris in English law seems to be gradual. Okay, first of all, okay, the English courts established the doctrine of juris to the effect that this doctrine this doctrine was limited in its application to just a threat to cause bodily harm. Okay, so when we talk about a threat to cause bodily harm, the duress in question, it is known as duress to the person. Okay, duress to the person, that means that it is the duress in the sense of somebody exerting a threat to cause bodily harm. Okay, so in the old days, English law seemed to hold the position that in order for a contract to become voidable on the ground of duress, the duress in question would have to be duress to the person. Okay, so this is how English laws was developed in the old days. Okay, and at first, when the limited application of the doctrine of duress, okay, seemed to be so narrow like this. Okay, that is, I mean, the doctrine was limited in its application to cases in which a person just exerted a threat to cause bodily harm to another person. So later the courts felt that, well, to limit the application of the doctrine of duress only to threats to cause bodily harm seemed to be it seemed to be not quite reasonable. Okay, so that later, the more recently, the English law, the English law was developed by courts to the effect of, to the effect of what? To the effect that the doctrine of duress could also apply to threats to cause harm to, or to cause harm to property, or to cause, distress of property as well. So when we deal with the situations in which the threats, it is the one to cause harm to property or to cause distress of property, we call that duress as duress to goods. So you can see that the law was developed, starting from starting from the court establishing the doctrine of duress, which applied only to cases of duress to the persons. Then the doctrine was developed to the effect of the expanding its application to also cases involving duress to goods, i.e. the cases which were concerned with the assertion of a threat to cause harm to or to cause distress of property as well. Later English courts seem to push forth further development of the doctrine of duress, in order to cover also the threats to cause economic catastrophe as well. When we talk about the duress in the sense of exerting a threat to cause economic catastrophe, then the duress in this way, the duress in this fashion, it is known as economic duress. We can classify duress cases into cases of duress to the person, duress to goods, and economic duress. These are three cases. If we trace development of the doctrine of duress in English law. But nowadays, we don't need to classify duress cases into three types like this, simply because nowadays the court seem to merge all duress cases. All cases can can just boil down to just the same thing, i.e. be it duress to the person, duress to goods, or economic duress. The threat in question leads to what? The threat in question leads to the threatened party having no practical choice. When A, let's suppose that we have again A and B. When A exert a threat against, when A exerted a threat on B in this case, when A exerts a threat on B in order to just in a way force B to enter into a contract with A, in this case, with the threat in question, it is the threats in the form of, the one causing bodily harm, or in the form of the one causing harm to or causing distress of property, or in the form of causing some economic catastrophe. Okay, so the person who is threatened just will just have what? Will just have no practical choice. Okay, so that the will of the threatened party is not generally free. Okay, the will is just overboard. Okay, so that when the will of that party is overboard, then there is no the justification for upholding the contract. Okay, the party who is threatened should elect to just set aside the contract. Well, it's up to him. Okay, if he just would like the contract to stand, then fine. But if he does not want to to just be bound by that contract anymore, okay, that person who is threatened may just choose to choose to just what? Avoid or set aside the contract. Okay, so that person may just put the contract to an end. Okay, as a result of duress exerted by the first party. Okay, so let's talk about the duress to the person yet. Remember, I have brought to your attention that the English courts seem to develop the doctrine of duress gradually. Okay, starting with the duress to the person in the old days. I should say in the old days again. Okay, that means that the position nowadays is not like that anymore. Okay, so but in those days, the doctrine of duress was so narrow. It was limited in its application to cases in which a person exerted a threat to cause bodily harm. Okay, to another person. Okay, so it is a threat of, in a way, it is a threat of what? A threat of physical violence. Okay, a threat to cause bodily harm. Okay, if the threat in question was not the one, the causing bodily harm, or a threat to cause physical violence, then it is not duress to the person. Okay, so when it is not duress to the person, that means what? That means that the threatened party could not have any remedy. Okay, so if we look at authority on this point, okay, we can have just this case, Skid and Bill. Well, for your information, okay, in the UK, in England, okay, they normally contract law principles are in the form of case law. Okay, case law means what? Case law means the principles of law which have been established by courts through decisions of the courts. Okay, so that in this country, in Thailand, okay, we have the provisions of law in the civil and commercial code. So that when we talk about, let's say, duress, we talk about section blah blah blah. But in English law, okay, when we just study English law, most of legal doctrines, most of legal principles are in the form of case law, i.e., they have been created, they have been established by courts through decisions of the courts. Okay, so normally, in the UK, we students, and lawyers do make use of cases. As for that, we talk about duress to the person. Okay, so the authority is Skid and Bill. When we say, well, when we make use of Skid and Bill case, it is the same way as quoting provisions of law in this country. It is the same thing as quoting the 11 provisions of the civil and commercial code in this country, in Thailand. Okay, so if you go to study law in UK or in US or in any common law jurisdiction, okay, you are expected to remember leading cases. You don't need to remember all cases. That is impossible. But on any particular points, you are expected to remember leading cases when when instructor, when the law teachers want to test you on any principle of law. Okay, you are expected to just give us the names of cases. Okay, name of leading case which are relevant. Okay, to the point in respect of which we are going to test you. Right. So now let's come back to, the duress to the person. As I have mentioned, in the old days, okay, the duress or the threats, which could provide a ground for, for action, was limited in its application to what? The principle, the doctrine of duress, okay, the duress or the threats, which could provide a ground for claiming that the contract was voidable. Okay, it was a duress to the person only. Okay, so if the duress in question was not duress to the person, then the person who was threatened could not have remedy. But the person who was threatened could not sue, okay, the person who exerted the threats in question. Okay, so in Skin and Bill, what happened was this. Okay, this case was concerned with a lease, between the two parties. Of course, one party was the lessor, the other one was the lessee. Okay, so in the lease, of course, the lessee would have to pay what? The lessee would have to pay the rent, of course. The thing is that the lessee did not pay the rent. When the lessee did not pay the rent, then the lessor just exerted threats. The lessor just threatened the lessee this way. The lessor just said to the lessee that, well, let's say if you do not want to pay the rent, then the lessor, I will just sell the premises, and I'm sure that you will not have, any place to live in. So in this case, the tenant, the lessee was in great worry, because if the lessor just sold the premises, then the lessee did not have any place to live in. So the lessee, in fact, had this fear, so that the lessee just, pay the rent which was in arrears, okay, at that time, okay, in order to avoid interest of the premises. Okay, so after that, when the lessee was no longer threatened, the lessee wanted to get the rent back, the rent which the lessee had paid to the lessor. Okay, so that in this case, where the lessee tried to recover, the payment of the rent, the lessee argued that, well, the payment of the rent was made, under duress, so that, payment would have to be declared voidable because it was made under duress. Okay, so in this case, it was held by the court that no, in this case, even though it was a threat, this threat did not in any way, okay, operate in the way of what? In the way of causing bodily harm to the lessee, so that when the duress in question was not duress to the person, it was not the threat to cause any bodily harm, okay, on the part of the lessee, so that this threat did not provide any ground for remedies. Okay, so that the payment which had been made by the lessee could not be recovered. Okay, so the principle of law established by this case, appear to be that the contract or anything which was made, okay, that could be declared voidable on the ground of duress only when the duress in question was duress to the person, i.e., the threat to cause bodily harm, or the threat of physical violence. Okay, if the duress in question was not of this kind, then the duress in question could not provide any ground for the claiming that the contract or the action in question became voidable at all. Okay, so that is the limitation. Okay, plaguing English law, plaguing the doctrine of duress in English law in the old days. Again, in the old days. Okay, so not anymore now, right? So if we get back to this diagram, which show you the gradual development of the doctrine of duress in English law, okay, we can see that, in the old days, okay, courts did establish the doctrine of duress in a way that, okay, duress which could provide a ground for the voidability of a contract or voidability of any action, okay, would have to be duress to the person, i.e., i.e. the threats to cause bodily harm or physical violence on the part of the other party. If not, then it could not provide any ground for the voidability of the contract. Okay, so now when we had limitation like this, just give me a few moments to just turn off my mobile phone here, because I am afraid that in the course of my lecture, then when somebody might just call me and cause disturbance. Okay, that in the course of my lecture. Okay, so now I cannot hear any sound anymore from this mobile phone. Okay, so let me just continue my lecture now. Okay, so when the doctrine of duress seemed to be limited in its application to cases involving duress to the person, i.e. threats to cause bodily harm, then there are many cases which were concerned with threats. Okay, did not fall within within the ambit of the doctrine of duress. Okay, so that later courts appear to expand the doctrine of duress to the effect of covering duress to goods as well. Okay, to cover the cases dealing with duress to goods as well. Duress to goods depicts a threat, the exertion of a threat in the way of what? In the way of causing harm to or causing distress of goods or property. Okay, when we say goods here, we mean property. Okay, so duress to goods, put simply, it is the exertion of a threat in the way of causing harm to property or causing distress of property. Okay, so we have on this point the authority from this case, Musgrave and Horner. In Musgrave and Horner, the leading case on this point, okay, what happened was this. Okay, what happened? Okay, the plaintiff had a store in the market, and the plaintiff was demanded by somebody to just pay tolls. Okay, money, of course. In order to be able to just run business at the plaintiff store in the market. Okay, so in fact, the person who demanded payments of tolls did not have any legal authority to demand payment. Okay, so in this case, that person just exerted the threat this way. That person threatened that, well, if the plaintiff did not pay the tolls, then the defendant, the one who demanded the payment of the tolls, would just close down the plaintiff's store in the market. So in this case, the plaintiff was in fear of what? In fear of losing the store in the market, in fear of having his store in the market destroyed or damaged by the defendant. Okay, so this is the threat exerted by the defendant on the plaintiff. Okay, so after that, the plaintiff who had paid the tolls claimed that, well, payment of the tolls, okay, was not out of his own free will. It was in fact a result of the threats. Okay, the threats to cause damage to the store. Right. So in this case, the plaintiff sought to recover the tolls which had been paid by the plaintiff. Okay. So of course we have the threats. The threats in question was what? The threats in question was the threat to just cause damage to the store in the market. Was that duress to the person? The answer is no, it was not duress to the person, but it was duress to what? Duress to goods. Okay, a threat to cause damage to property, or the threat to just cause distress of property. Okay, so it was in a way, okay, the duress to goods. Okay, so we have this situation, okay, involving duress to goods. Okay, so the question to come to the court was whether or not this kind of duress was actionable, whether this duress could give rise to a ground for claiming the payment of the tolls back. right? So the court held that, well, if we just been applying if we just apply the law in those days, remember, on the authority of skin and bill, jurors which could provide remedy was limited only to jurors to the person. But in this case, in Muscat and Horner case, the jurors in question was not jurors to the person, but it was jurors to goods. But the court just feel that there should not be any difference, between jurors to the person and jurors to goods. If jurors to the person could provide remedy, if jurors to the person could, make the contract in question voidable, then jurors to goods could lead to the same consequence. Okay, so that in this case, the court in a way expanded, the doctrine of duress to cover jurors to goods as well. So we can see that from jurors to the person, okay, to jurors to goods. You can see this now, right? In those days, the doctrine of duress could be applied to how only the persons, only the person who was, threatened, when that threatened party, was in fear of what? Was in fear of bodily harm, okay? But later the court tried to just expand or extend the doctrine of duress also to cover any threats to cause harm to or to cause distress of property as well. Okay, so the treatment, legal treatment should not be different between, a threat to cause bodily harm and a threat to cause harm to or to cause distress to property. Okay, so the consequence seems to be the same, i.e., okay, whether it is duress to the person or duress to goods, then the contract or the action in question would have to be voidable when the person who entered into the contract or the person who did that action, did so, under duress, under duress as a result of the threats, right? So now, when the English court expanded the doctrine of duress to be much broader, the later English courts did some further development in a way that the doctrine of duress could also extend to cases involving a threat to cause economic catastrophe. We call this kind of duress as economic duress. Okay, so the most simple case it is the case where, let's say that one party, let's say that A and B, they have entered into a contract, and of course when A and B have already entered into into a contract, let's suppose that later, A, maybe A wanted to demand something more than what the contract conferred upon him. So A just threatened B like this. A would say this to B. A would say, well, B, if you do not agree with what I demand from you, then that means A, I will just commit a breach of contract. I will just break this contract. If B does not want to agree on what is demanded by A, then A will just do what? A will just break this contract. If A just breaks this contract, then B will suffer great loss. Maybe the contract is so important. Maybe, the B relies on something very important under this contract. So if A just breaks this contract, then, even though B can just sue A for damages resulting from A's breach of contract, but sometimes, the litigation does not seem to be the best solution, because B's business may be ruined, very much, So that's why when A exerts a threat on B in a way that if B does not agree to what is demanded by A, then A will just break the contract, B is in fear. B is in fear, of what? Of not having the benefit under this contract. Okay, because let's say that A sells the goods to B and B relies on these goods very much. Maybe B will have to resell these goods to somebody else. So if A is in breach of the contract with B, B will not have goods to be delivered by A under the contract, so that B will not be able to deliver these goods to B's customers. Right, so in this case, B's business may be very much ruined. Okay, so that B will just agree to what is demanded by A. Let's say that A said this to B. I say, well, B, you will have to pay me 10% more. You have to pay me 10% more. The contract between us, okay, the contract between A and B just fixes, a price. But now that means A, okay, I demand you to pay me 10% more. Right, so B is in fear, okay, of not having the goods from this contract in order to deliver these goods to somebody else. Okay, so that B does, B just agree to pay A 10% more. Okay, as per the demand by A. Okay, so this is a threat, of course. Is this threat duress to the person? No. This threat, it is not duress to the person because A does not cause any harm to, A does not cause any bodily harm, right? And in this case, it is not duress to goods because A does not cause any damage to any property. A does not cause any distress of any property, right? But in this case, it is a threat which can do what? It is a threat which can cause great economic catastrophe on the part of B, okay, on the part of the party who is threatened, okay, because if A does not perform obligations under the contract between A and B, then the B's business will be damaged very much. Okay, so that this kind of threat, this kind of duress is known as economic duress. Right, so we can see that now, right? The doctrine of duress seems to be very, very extensive in its application. Okay, it applies to cases dealing with threats to cause bodily harm. It also applies to cases involving a threat to cause harm to property or to cause distress of property. And it also covers situations involving, the threats to cause economic catastrophe as well. Okay, so now, now today, when English courts deal with cases of duress, they do not seem to just, fit the case in question into any type of duress. They don't need to just place it under, the category of duress to the person, duress to goods, or economic duress. They can just merge all cases to have just one principle of law. Okay, the doctrine of duress. Okay, they can just merge these ties, all these three ties of duress into any threats which leads to the other party having no practical choice, so that the will of the threatened party is overborne. Okay, so that in this case, the party whose will is overborne can just have remedies. The contract in question will be voidable and can be set aside by the threatened party. Okay, so this is the position in English law. Okay, so if we talk about authorities, okay, the authorities regarding economic duress, we have at least two leading cases. Okay, these two leading cases are very well known in the English common law. Okay, the first one is called Seaborn and Seaboard. Okay, when you get a case like this, okay, the beginning with the name like the followed by something. Okay, the please just bear in mind that this case is concerned with the ship, the vessel. Okay, so that normally Okay, if the case is concerned with the ship, the case name will be will retain the name of the ship. So in this case, okay, it was concerned with two vessels. Okay, the first one is named the Sibon, okay, and the other one is the Sibot. I think that may be the French name or what. I can't remember. I'm not quite sure. Okay, so the second case on this point, on the point of duress or economic duress, okay, it is the case named the Atlantic Baron. Okay, so normally, when you get a case like, like this, which of course, as I have mentioned to you, which is concerned with the name of the ship, you will also be, given the full name of the case. In the first case, the Simon and the Seaboard, the full name is the Occidental Worldwide Investment Corporation and Skips. Similarly, in the Atlantic Baron case, okay, the full name is North Ocean Shipping Company Limited and Hyundai Construction Company Limited. Okay, so let's have a look at these two cases. Okay, and starting with the first case, the Seaboard and the Seabot, of course, it was concerned with two ships, as I have mentioned. Okay, the first one is the Seaboard, the other one is the Seabot. Okay, this case was concerned with a charter party. You know what this word, charter party? The charter party is something like this. Okay, it is the contract to take the space in the ship. Okay, to take space in the ship or to use the ship, put simply. Okay, so that there are two parties. Okay, a charter party has two parties. The first one is the owner of the ship. We call this one the ship owner. Okay, the ship owner. The second one, it is the charterer. Okay, so two parties, ship owner and charterer. So that charterer will just use the ship or will just have the space on the ship for the carriage. The charterer will have to pay freight, okay, in return for the use of the ship. Okay, so this is the general picture of this. There's a kind of contract known as the charter party. Okay, charter party. So that in this case, right, there was charter party. In fact, two charter parties. Okay, the charter party for the Seaboard and the charter party for the Seaboard. All right. Of course, the charterers would have to pay the freight. Right. The thing is that the charterers did not want to pay, the freight as fixed by the contract. So the charterers just exerted the threats on the ship owner. The charterer demanded the ship owner to just reduce the freight. Charterer just demanded the ship owner to just amend the charter parties for reducing the charter rates. Okay, so they wanted the ship owner to do what? They wanted the ship owner to just make amendment to to the addenda. For these charter parties, the addenda just set the rates of the charter, the rates of the charter, i.e. the freight. Okay, so that when the charterers threatened or exerted the threats on the ship owner, right? The threats operated like this. The charterers said that, well, the ship owner, if you don't reduce the rate of charters or the freight, then we, the charterers, would have to leave this charter party. And we know that you will not be able to find other charterers on time because now the market doesn't seem to be very good. Okay, so if we quit this contract, then you will be finding it very hard to look for other charterers. Okay, so in this case, the ship owner had a fear of not being able to find other charterers. Okay, so that the ship owner agreed to reduce the rate of freight. The ship owner just made amendment to the addenda pertaining to this contract or this agreement. Okay, for the purpose of reducing the rates of rate of the freight, right? So after that, the ship owner just claimed that, the reduction of this freight would not be valid because it was made under duress. Okay, so the point which would have to be decided by the court was whether or not, that this agreement, the agreement to just amend the charter rates was voidable on the ground of duress. Okay, so you can see that the threats in this case, it is something like this. If you, the ship owner, if you don't want to agree to reduce the rate of charters, the rate of freight, then we, the charterers, will have to leave this charter party. See? So was that the duress to cause any bodily harm? No. Was that the duress to cause any damage to property? No. Was that the duress to cause any distress of any property? No. Okay. So if we get back to these three types of duress, the duress in this case, the duress in the sport did not constitute the duress to the person. It did not amount to duress to goods, but it could be economic duress because it was a threat to cause some economic catastrophe, right? The ship owner would suffer, great loss, great financial loss, okay, if the charterers just quit this charter party, okay, so that in this case, it was held that the agreement, of course, what kind of agreement was this, okay? The agreement to just amend the charter rates, the agreement to reduce the rate of freight could be voidable on the ground of duress, okay? So this addenda, the addenda which were made in order to reduce the rate of freight, okay, were voidable. They could be voidable on the ground of duress, okay? So when they could be voidable, that means that the ship owners could just set aside these addenda, okay, so that on this point, the court addressed this speech. You can see this speech, okay? They may be coercion or compulsion not amounting to actual or threatened physical harm to a party to an agreement, okay? Or amounting to actual or threatened physical detention of its goods, which constitutes duress at common law, provided that the pressure was such as to obey the will of the party and thus to vitiate the consent of that party to the agreement. That was addressed by Justice K. Okay, what is meant by this speech is this. Even though what is meant by by Justice K in this one, the duress in question did not constitute duress to the person. It did not constitute duress to goods either, but it was economic duress, okay, in the sense that it was a threat to cause economic catastrophe on the part of the ship owners, okay. So it should be treated in the same way as duress to the person or duress to goods. The consequence should come to the same thing, i.e. the contract or the agreement in question would have to be voidable on the ground of duress. Okay, so from this fact, from this case, we can see that the doctrine of duress in English common law now becomes broad enough to cover everything. It can cover duress to the person, it can cover duress to goods, and it can also cover economic duress. It can cover anything, okay, anything under which the party who is threatened will have no practical choice, okay, so that the will of that party is simply overboard, okay. So this is the position declared by the court in this case. Now, in addition to the seaboard and the seaboard, we also have this case, the Atlantic Baron, okay, as an example, okay. In this case, what happened is this. There was a contract, okay, a contract for the construction of an oil tanker. Let's suppose that we have A and B, okay, for simplicity. Let me just explain to you using the language A and B like this. A is what? A was the builder of an oil tanker. Okay, so A would build an oil tanker for B. Okay, the contract was made between A and B. Under this contract, B would have to pay A in US dollars. Okay, B would have to pay A in US dollars. Okay, after the conclusion of the contract, the dollar, okay, US dollar was just devalued. When the US dollars became devalued, who would be affected? Of course, A. Okay, because A would get payment in US dollars, which became much less worth, right? So that when A suffers some loss because of the, because of the dollar being devalued like this, A would have to remedy his loss. A just exerted threats on B. A just demanded B to pay 10% more. He said, well, B, pay me 10% more. If you don't pay me 10% more, then we are not, okay? If you don't pay us 10% more, then we, the builder, would not just, build the oil tanker for you, and we know that, you will be in trouble because you would have to use this oil tanker, for something very urgent, okay? So if you cannot get this oil tanker on time, then you will be in trouble. So please pay us 10% more, okay? This is the demand addressed by A, right? You may see that, well, B can just sue A if A want to just break the contract like this. But as I have mentioned, okay, litigation does not seem to be, a satisfactory choice sometimes, okay, because B's business might be very much ruined, okay, so that in this case, B does agree to pay A 10% more. Right. When B agreed to pay A 10% more, after that, the A did not want to pay. A did not want to pay, okay, the additional sum. So A contended that, the agreement to pay such additional sum was made under duress. So we have, in this case, duress on the part of whom? Duress threats exerted by whom? Exerted by B against A. Right. Exerted by A against B. Remember that A said, well, if B does not want to, if you are B, okay? If you don't pay us 10% more, then we, A, will not build, the oil tanker for you. So in this case, we can see that the agreement on the part of B to pay A 10% more, it was a result of what? A result of a threat. A threat to cause what? A threat to cause some economic catastrophe on the part of B. Right. So in this case, it was here that this was economic duress, which could provide a ground for remedy. Okay, so the contract, the agreement to pay 10% more here could be declared voidable and could be set aside by whom? By B. Okay, so B could judgment avoid this payment of additional money. Okay, because the agreement to make the additional payment was made under duress. Okay, so if we compare this one with Thai law, and this is very important. Okay, we have seen that the English doctrine of duress seems to be very, 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 very extensive in application. Okay, it can cover the case of duress to the person. It can cover the case of duress to goods, and it can also cover the case of economic duress. Now, if we just come to Thai law, I hope that you all can remember, okay, the positions of Thai law here on this point. Okay, according to the principle of duress in Thai law, remember we have section 164. Okay. We have section 164 of the Civil and commercial code, okay, 164 provides as follows. The declaration of an intention under duress is voidable. See, and then, okay, the paragraph 2 go on to says, duress which renders an act to be voidable must be one which causes a danger that is imminent and so severe as to lead the threatened party to be in fear, and without which the act in question would not have been made. We get the word here. We get a keyword here, danger. Duress in Thai law, okay, must be in the form of what? In the form of a threat to cause a danger. Okay, so when Thai law uses the word danger here, normally the perception, the interpretation seems to be quite narrow. Okay, so the word danger tends to be interpreted as meaning some harm to what? To property. Okay, so it might be interpreted to cover sort of, the kind of economic catastrophe, so that the application of section 164 may lead to the consequence that the doctrine or the principle of duress in Thai law does not cover economic duress. Okay, so this is the limitation in the limitation which we find in the principle of duress in Thai law. And you should also recall one more thing, okay, when we deal with the doctrine or the principle of duress in Thai law, okay, there are also some threats which are not regarded as what? As duress in Thai law. There are two threats, remember, two threats which are not regarded by Thai law as duress. The first one is what? The first one is a threat to resort to the normal exercise of a right. Remember, the second one is reverential fear. It is not duress. Remember, you can remember these two threats which are not regarded by Thai law as duress are stated in the section 165 of the CCC. 165 of the CCC provides as follows: a threat to resort to the normal exercise of a right is not regarded as duress. And then paragraph 2 goes on to say, and any act carried out on account of reverential fear is not regarded as an act carried out under duress. So that the two threats, 1 and 2. One is a threat to resort to the normal exercise of a right, and the second one is reverential fear. These two threats cannot constitute duress in Thai law. Okay, so that if we can remember the cases in Thailand, we have the case where what? Let's say that I just exert a threat on you like this and say, well, I know that you have committed something wrong. You have committed a criminal offense. Okay, I can just press a criminal charge against you. If you do not want to be put in jail, if you do not want me to just, take legal proceedings against you, why don't you do this? You can sign an agreement with me. Okay, if you agree to sign an agreement with me, will you be able to claim that the agreement which is made, it is made under duress? The answer is no. Remember, because the threat in question is a threat to resort to the normal exercise of a right. If you have committed a criminal offense against me, I have the right under law, okay, to just bring you to court. I have the right under the law to just take legal proceedings against you. So when I just threaten to just pursue legal proceedings against you like this is not duress in Thai law. But we shall see later that in this kind of case, okay, English doctrine known as undue influence can be of help. If I just threatened you like this, okay, I just say that, well, if you do not want to sign an agreement with me, if you do not want to make an agreement with me, then I'm going to just report this case to the police about, your commission of this crime, okay, so that you do not want to be taken legal proceedings against, so that you just agreed to just enter into an agreement with me. In this case, in English law, this constitutes undue influence, so that the contract in question, in this case, the loan agreement which you have made with me, can also become voidable. Okay, so that we can see that on this point, Thai law is not so efficient as English law in terms of the protection of the parties. Okay, in terms of making sure that the will of the party is free, and the party whose will is not free can have remedy. On this point, okay, on this point, Thai law cannot be comparable to English law. English law efforts grant protection to persons who suffer injury. I mean, in this kind of cases, right? When we deal with the doctrine of undue influence, we will see this. We will see much clearer picture. Okay, so now I think that it will require us about 1 hour more. Okay, to finish the lecture. So I think that today we are tired. Okay, you are tired. I am also tired. So I think that we can just defer our discussion of the English doctrine of undue influence to next Monday. Okay, so today we deal with only 2 doctrines: the doctrine of misrepresentation and the doctrines of juris in English law. Okay, you seem to have the picture that Thai law seem to be much narrower than English law in terms of protecting the parties against the will which is not free. Okay, so we will see a much clearer picture when we deal with the doctrine of undue influence next Monday. So that's it for today, and see you next Monday. Thank you very much for your attention. Okay, see you. Bye bye.